Welcome to our Ask an Expert show, where I invite a fellow professional in the US-UK cross-border space to come in and talk to me about the issues we think Brits in America need to be aware of if they are going to thrive here. My guest today is Paula Jones. Paula is the principal and founder of Jones Estate Group, a law firm based in Philadelphia, serving clients across the US and internationally in matters of international and domestic estate law. Paula is an American, although she is now also a Brit, and she helps international people, which for our purposes that means Brits in America, to set up estate plans that protect them and their families in the US without inadvertently triggering adverse consequences outside the US. This conversation is hot on the heels of my conversation with Aidan Grant, where we got really specific on some of the details, nuances, and pitfalls of US-UK cross-border estate planning, so this conversation is the icing on that cake. As a Brit in America, with some or all of the cross-border estate planning issues and challenges that we face, as highlighted in this podcast and my podcast with Aidan, how do you go about putting a US estate plan in place that is fit for purpose, that doesn't trigger any adverse consequences, and that doesn't bankrupt you in fees? Well, Paula is going to tell us just how right now. So without further ado, let's get into this. Hi, Paula. Welcome to We're the Brits in America.
Thank you. I'm very happy to be here. Thanks so much for the invite.
I am really excited to have this conversation. As I said, I've had a great conversation with Aidan, and I feel that this is such both a critical topic and it is a widely misunderstood, if it's even known about by people. So the fact that I could get you on here to kind of tie this up for us, like go from like the cover the challenges people face to the, all right, great, what do I do? How do I solve this? So I'm really excited to have this conversation.
Yeah, it is important to realize that it's a unique area, even among U.S. attorneys. There are very few of us who actually do cross-border work, also known as international estate law. It means all the same thing, that we're working with what I call multinationals, people who have a relationship with the U.S. plus a non-U.S. component to any aspect of their life, whether it's their citizenship, residency, they're married to someone who has a non-U.S. component, their children have a non-U.S. component. Some of the newer trends I'm seeing is we have, fully U.S. people who wind up with non-U.S. grandchildren, much to their surprise.
Oh, yes.
The world is, getting smaller and smaller and smaller. And in doing so, there are, many, many cross-border issues that crop up more and more each day. So it's a fascinating area. It's interesting. It's complicated, but our job as advisors is to make sure that it is nice and clear and well organized and not overwhelming to the client.
Speaking to that point you made about, there's not many in your space. There's a lot of estate planning attorneys. There's
Yeah.
not many internationally focused. I have been at this in America for nearly 10 years. I have known of UK-based, UK-US estate planning attorneys who can do some of the stuff in the US, but they can't do anywhere near sufficient that a US-based person needs. And I have, outside of the very, very, very big firms, which is just outside of the realm of possibility for the people we work with.
Yeah.
Until I came across you and I started following you on LinkedIn, I started engaging in your stuff and realizing, oh, there's someone here who this is what I've been looking for. It took me in this space.
Yeah.
I don't know when we connected on LinkedIn, but multiple years. Mm-hmm. So there really is, it is, that's a problem, because is it the same? And I'm sure it is. And I know it is because I see it all the time in the tax world. It's a similar story, right? In my opinion, expats, anyone with international issues needs a cross-border tax advisor.
Yes.
But there are very few of them, and there are many, many more domestic focused tax advisors who are more than happy to take on international clients or people with international wrinkles without the knowledge, whether they just don't know what they don't know, or whether they're intentionally taking people on when they're not equipped to advise them. I don't know. But that's a real problem, and I imagine it's exactly the same in estate law, where you got expats going around engaging a local attorney and coming out with something they shouldn't have.
Yeah, it's very common. So the expression that I use all the time, because I do a lot of speaking to other estate attorneys on aspects of international. One, to raise awareness of them, But I do get much of my clients come from other U.S. estate attorneys who, an international issue walks into their office and they at least know enough to say, this is not me. I don't know enough about this. So the expression we all use is, we don't know what we don't know. You don't even know what questions to ask because you literally have no frame of reference about an international estate client. So fortunately, some of them are wise enough to know what they don't know, and they hand it off to someone who does, in the same way that I do that as well. In other areas of estate law that I don't focus on, I hand that off to someone else. There are not many of us, but it's certainly helpful when those attorneys know enough to hand it off. The other thing too, and this is kind of my general, I don't know, excuse maybe for that U.S. centric view. There is a bit of a difference between the U.S. and the U.K. and that in the U.S., first of all, we are a massive, massive country. And for someone to leave the country, unless they're going to Canada or Mexico, obviously, they have to get on a plane to go somewhere. And so, the amount of international travel that is done in the United States is not as much as it is in other parts of the world, simply because if I get in the car here and I drive for 2 hours, I'm in the same state that I started in. And there's 50 of them. If I'm in the UK and I go somewhere 2 hours later, I'm in a completely different country. There is a difference there. So
100%.
Yeah. And so that does come across where we do have other advisors who have this America-centric view. And as soon as anything international kind of comes their way, they get all nervous about it or something. So, and I don't find that so much in Europe or Asia. It's people are used to working with people that have a connection to another country. So I don't know. That's an excuse. Maybe it's a poor one, but there it is.
The flip side to that is there's a real smugness about Brits, and that whole thing that's lobbed about Americans. Oh, they don't have a passport, they've never travelled. I'm like, you've only been to Spain. That's like an American going from Massachusetts to Connecticut,
Exactly.
right? You've not been anywhere either, mate. It's just a classic British snobbery. That
it's funny you say that because my 7 members of my British family all came to the U.S. last summer. And when I go there, when I visit, I usually say, well, can I zip off to another country while I'm here? I'm only here for 7 days, but, let's go to the Netherlands or something, or let's go to France or whatever. And when they came here, they had never been to the U.S., and this was a huge trip for them. However, I said, oh, well, you must have been to France and the Netherlands. I mean, you just hop on the train and it's 2 hours. No, they haven't been. And I said, oh my gosh, if I lived in the UK, I would go everywhere, but it's whatever you're used to.
We're getting off topic here, but but I'll just tell you, I have my it's not a theory. My belief is that in Britain, we take Europe completely for granted. So, and I did. And then I left the UK and I was in the Middle East for a while. Now I'm in America. And going from having Paris, Milan, Rome, Spain on our doorstep, an hour, 2 hours, 3 hours away, I took that totally for granted. And when it was taken away from me, I realized just what a gift that is. And now, but it means that when I'm there, I appreciate it so much more. I drink it in. I reckon I'll travel more as a result of this. But in the UK, you grow up, you just take it completely for granted because it's on your doorstep.
Yeah, so true. So getting back, that's it's important for us to realize that you need the U.S. attorney. It's important that if you're working with, whether it's a U.S. attorney and you're probably also working with a UK attorney, that you're working with the right kind, and that's going to be a cross-border attorney. So for instance, I will have clients who come in here and maybe they own real estate in another country, and normally it's a fairly universal concept that if you own real estate in another country, you're probably going to need a separate will in that particular country, even if it is just for the real estate itself. And a lot of people will say, oh, well, the attorney who helped us buy the house there, we'll just use them to do the will. And I say, no, you need the cross-border attorney, because they need to know that that will has to match up with the U.S. estate plan, and they have to coordinate together. And one of the specific reasons why is most wills start out by saying, this is my last will and testament. I revoke all prior wills and codicils prior to this one. Well, in doing that, if you have done a UK will and you did it last year because you still keep your real estate there, and then you do one in the US, you have just revoked your UK will. And you did not mean to do that. So unless you have cross-border attorneys to spot those issues for you, because we don't know what we don't know, that may be done.
That's obviously something I'm familiar with, in theory. But as someone on the ground, do you see that a lot? Do you see a lot? Do you encounter clients a lot where they've inadvertently cancelled a will they didn't mean to?
Maybe I work with slightly more sophisticated people. I don't see it a lot. I see well-meaning people say things like that to me in a meeting where I will say, oh no, Now, they've come to me as a cross-border client. They may be referred by another cross-border attorney or something, so there is a little bit of an understanding, or certainly from another estate attorney, so there is an understanding of, you need to be careful here, you need to tread lightly. Some people have had that experience as well. Most people, that they have the income tax under control, and they have learned the hard way, just how far of a reach the U.S. does have, well past our borders into anything that you're doing globally. And so they might have some understanding that the same concepts may apply to in the estate area. However, it absolutely happens, or afterward, even, we put everything together in the U.S. and kind of, 5 years later, we're regrouping again because of some changes needed. And we always do a review of, okay, what do you have in place? Give me the asset update. How are things titled? What other legalities do you have in place? And maybe they went off and did something. We sold a house. We bought a house. We did this. Most clients, whether they're cross-border or not, sort of run off and do things, and then they call their attorney and say, oh, I did this. Is that a problem? So there's a lot of that. Sure. I mean, we get that all the time.
Yeah, it's really interesting to hear you categorize what you said a minute ago, that most people have the income stuff under control, but they've learned the hard way about the long arm. And that's exactly my experience. And we're very, sadly and frustratingly, we're very often the people who point that out.
Right.
People will come to us saying, I need some help with this, I need some help with that. And in learning about their situation, we're the ones who uncover, you shouldn't have that, or this is going to be a problem. And they learn the hard way.
I think what's also really important, and as you said, outside of kind of massive firms, it can be difficult to focus on an international advisor. To that end, I think I've had a lot of conversations over the last 15 years with people trying to get into compliance with their income tax. They did not realize, as is so easy to understand, that they did need to file a U.S. tax return, or they did need to report, bank accounts that are in another country. And why would they do that? There's nothing intuitive about those rules. And so some people miss those rules. And in doing so, I think not having the knowledge or not having a good team of advisors leaves people vulnerable to an advisor in the U.S. who scares them all the more and says, oh, this is a terrible, terrible problem you've done, and it's going to cost, a ton of money to get it all fixed. So I've done a lot of the cleaning up of foreign account compliance filings, for instance, having to update the income taxes and get a packet to the IRS, the streamlined entries, those kinds of things. I've done a lot of that work, and that does not have to be a scary proposition, and it does not necessarily have to be this incredibly expensive prospect to get those things back into compliance. So I think not having this good team of advisors, meaning the accountant who does cross-border and the attorney who does cross-border and kind of a network, just feeling like you're part of a network, even of other people who are part of a cross-border and they have cross-border advisors, and just being able to bounce ideas off and say, well, wait a minute, I received this quote from this firm and they said this or whatever, and at least gauging that, are they kind of being taken advantage of by the vulnerability of being, in a complicated position.
That's it. The network you've hit on, that's I believe that's the key. People come to America to be successful. It's a land of opportunity. People go to Europe for different reasons, but Brits come to America to be successful for their career opportunity. And what we see is they've been here for 10, 20 years and they've been successful. They've built up wealth. They've got complicated affairs. Even sometimes when they don't have stuff in the UK, most of them do, but not all. But they've still got complicated affairs. And at that level, it's a network. No one person has all the answers. And you need an accountant, you need a financial advisor, you need an estate advisor, you may need some other help as well. But you want all those people to be cross-border.
Yep.
You really do.
And to that end, so I'm sure people understand that and would say, yes, I would love all that kind of support. But then the fear is, what are the fees going to be for all of that, right? Terrifying. Yeah. Okay. So this is one of the huge misunderstandings. Fortunately, it's a misunderstanding from a lot of clients is, they call it. I just received something the other day. Someone said, I'm US but I own a house in France, and can you do all of that for me? I understand you do cross-border, and this person is expecting me to be able to practice US and French law all together and be a one-stop shop. Unfortunately, that's not the case, right? So we are admitted to practice law in the United States, in particular states, and so I do not try to practice the law of other countries. One, I'm not allowed to, but two, I'm not going to do something that I have no knowledge in the same way that advisors in other countries, if they are not admitted to practice law somewhere in the United States, they should not be advising on U.S. law. I do see that. Sometimes very sophisticated clients have said, oh, well, we had all of our advisors in Switzerland tell us that we could do this, that, and the other in the United States. And I said, well, next time you're going to need a U.S. tax advisor for those things, unfortunately. And you hate to deliver that message. Anyway, so in setting up the representation, this is how it's done. The U.S. is usually leads a little bit in the estate, in putting together an estate plan. And what I mean by that is because the U.S. reaches far beyond its borders, the U.S. estate plan may govern things that go beyond its borders, right? And so you're not necessarily going to get the same approach when coming from the UK. So on the UK end of things are generally... anything that is happening within the borders is handled within the estate plan, and it doesn't go beyond. So that's what I mean by the U.S. is a little bit of a leader in the estate plan, even though you need both. So what happens is you're going to have your U.S. estate attorney, and they're going to put together the plan because people are either resident here or citizen here, but that's going to be your leader. You may also need a separate estate plan in the UK. You may not. And it depends on the type of assets that you may hold there and your relationship back. Do you spend a lot of time there? Are your beneficiaries there? Is your family there? Are you here for only a few years, and then as soon as your job opportunity or whatever kind of lapses, your general plan is to go back? All of these things are, unique to each particular client. So we may need a separate advisor in the UK. And if we do, I can't tell you how many times that we'll put together the US plan and the UK advisor will take a look at it and say, yes, that actually will work in the UK as well. So, for
Okay.
instance, it is possible for someone to have a U.S. will and for the UK attorney to say, we could actually use that US will in the UK if needed at that person's death. And so, no, I don't think they need a separate UK will at this time. Now, I will tell you this, I'm not a UK attorney, but working with them enough, I can say, if you still have real property in the UK, you're going to need a separate UK will.
Okay. So this is for things. This might be accounts or
Yep. Yep.
pensions, not physical real
Exactly.
estate.
Exactly.
Okay.
Exactly. And then, under other scenarios, and the great thing about working with cross border attorneys is that we all know each other and we can usually shoot a quick email to say, here's the general profile of this client. Do they need something in the UK? If so, what would they need? And I'm going to get a quick email back from all my folks in the UK to say, well, they should do this, that, or the other, or no, you're good for now. Come back in a few years if their circumstances change, whatever, and that's how that works. So this fear of saying, oh, you're telling me I need two attorneys instead of one, my fees are going to be doubled. That is not actually true. I don't think I've ever worked with someone who has exactly double the fees, in each jurisdiction. That's a big fear.
So I'm in Connecticut,
Yeah.
and let's say I engage you to do an estate plan for me. Do I have to go and find a UK attorney and connect you, or it sounds like that's something you've got the network, you can plug into that very easily. It's not on me. You will determine
Correct.
if you need to have a conversation, and then if you need to engage them, will you handle that?
Absolutely, yes. So, I'm a member. So there are various organizations. There's STEP, which is Society of Trust and Estates Practitioners. There's the International Bar Association. There's a private client committee. There's a conference every year on that. I mean, we are all part of networks, and like you had said in the beginning, it's a fairly small group of people that we tend to know each other. So when someone says, "Yeah, I'm U.S. people and." Yeah, I'm in the US now, but I still have my pensions in the UK. We're hanging on to our London flat for a while. Do I need something in the UK? In that scenario, I can say, yep, you do. And I'll give you a couple of names of people who I know are not going to charge them the earth, who are not going to sort of try to take advantage and say that they have a more complicated situation than they do. We all tend to work together because we know if my clients are going to be happy with me, I know they're going to be happy with this other person as well.
Great. And what about from a state perspective? Because one of the stumbling blocks I've encountered repeatedly in my time here is, I thought you needed to. I thought we needed at one point. I thought we needed to find a cross-border estate planning attorney in each individual state, because it doesn't. Each state have its own rules and probate and all
Yes.
that stuff.
Yeah, it does. So let me speak to that a little bit. And this is something where, the U.S. Is always called out on all my. Earlier today, I had a call with my step group, and we have 8 different countries on the call, and we're all chatting, and we tend to compare notes about this is what happens in my country, what happens in yours, etc. So the U.S. is known for being somewhat complicated because not only are we a different country, but we have 50 separate states within. And each of the laws in those states is, of course, slightly different. So what does that look like in the estate context? First, let me talk about federal, because I think this can get rid of a lot of complexity, first of all. So we do have a federal estate tax here. The exemption amount for that federal estate tax is 13.61 million in 2024. So in other words, if I die with less than 13.61 million dollars, I don't have to worry about US federal estate tax. That's a lot of people just went, "Oh, phew, I don't have to worry about that." Okay? Because that's a very high number. That number is going to change in 2026. It is going to go down. It's going to go down to 6 million. Still, a lot of people just went, phew, I don't need to worry about that. Okay. So when we talk about wealthy, that's what we're talking about. We're kind of saying, very high net worth people are going to need to address US federal estate tax planning as part of their estate plan. Okay. Now let's talk about everybody else. There's also a state level of estate or inheritance tax in some states, but not in many others. So let me just throw out some examples. New York has a state level of estate tax. The tax rate is roughly 16%. It's a graduated rate. It's roughly, kind of around 16-ish percent. But there's also a exemption amount there, which is about 6 million. Okay. So New York, which tends to be a fairly high tax state, is one area where,
Just so I'm clear here, Paula.
yeah,
You say you're worth 100 million, so you're over both all exemptions. Are we talking 40% federal, 16% New York State?
yes, yes, they're
Yikes!
huge. They can be
Ouch!
huge. Yes.
Wow, I did not know that.
Yes. Yeah. So that's why people need to do planning. First of
Yeah.
all, that federal estate tax right now is a flat rate of 40%. It's a huge tax. It is historically larger than the highest income tax bracket. And historically, it tends to
Yep.
be that way. The philosophy being, you've just passed away, and therefore anyone who's receiving an inheritance from you, it's found money. So it's a whole lot easier to take a 40% chunk off of that because you never had that money to begin with, right? That's different than income tax where you're like, I'm working to earn this money, and you're taking that chunk out, it's more painful on income tax than it is on estate. That's the philosophy. I'm not saying I agree or disagree, but that's the philosophy. So then, yeah, you have to factor in the state level as well. So state of Delaware, for instance, got rid of their inheritance tax many years ago. So there is none. Florida, no inheritance tax. New Hampshire, no inheritance tax. You pass
Paula,
away. Yeah.
but am I right? Just being specific on the language, estate tax, right? Is it tax on the estate? When we talk about inheritance taxes at the estate level, sorry, it's tax on the estate. When we
Yeah.
talk about inheritance taxes, are we talking about a tax on the people who receive the money, as opposed to a
Correct.
tax on the estate, or is it state by state? Each has its own way of doing it.
It is state by state, and each does have their own. So, for instance, New York really is an estate tax, meaning the estate
Okay,
itself has to pay it and then the beneficiaries receive. And that
got it.
really is a practicality because at the end of the day, when you're administering anyone's estate, you have to make sure those taxes are paid first anyway. And so it's not as if you're going to give the money and then the beneficiary has to file anything and pay a tax. That's not how it practically
Okay,
works. You're settling an estate, any estate and inheritance taxes have to come off the top. And
got it.
then,
Okay,
and then beneficiaries can get, if there is something left for them to receive, they will receive it. But to answer your question, yes, the estate is paid from the estate. An inheritance tax, technically, the legal definition is that the beneficiary has to pay that tax. So New York is an estate tax. I'll compare that with Pennsylvania, which is an inheritance tax. So Pennsylvania says if you're a spouse, the inheritance tax, anything passing to spouse is 0%. If you're a child of the decedent, anything passing to child is 4.5%. It's a flat tax. There's no exemptions. So here's how that actually works. Let's say I'm a decedent. I left everything to my 3 kids. It's an inheritance tax, right? It's still, when the estate is being settled, the inheritance tax attributable to each of those beneficiaries is going to get paid first before those beneficiaries actually receive anything. Let's throw in a curveball on that one and say I left things to my 3 children and also $100,000 to my sister. My sibling tax rate in Pennsylvania is 12%. So my
right. Again,
sister,
no exemption. There's
no
no.
exemption. No, $1.
Right. Wow.
Yeah.
Wow.
So that $100,000 going to my sister, she is actually going to receive at the end of the day $100,000 minus $12,000. That's what she's actually going to receive. And the estate itself, when being settled, before she ever receives her inheritance, they're going to pay that $12,000. Okay. So, yeah, from a practical standpoint, it all gets paid first. From a legal standpoint, an inheritance tax, the beneficiary is going to receive the balance after their personal tax rate is paid. Yeah, that's the difference between estate and inheritance.
So I interrupted you mid-flow before. I apologise, but I think you were naming some of the states where there is an estate or inheritance tax.
Yep. So you're going to hear, Florida is popular for more reasons than just the sun. And one of that is they do not have a state level of income tax. They do not have any death taxes in that state.
Okay.
So it is a very popular state for people who say, if I'm going to pick a state in the U.S. in which to be resident at the time of my death, which is the cheapest one? So for at least for a state in inheritance, New Hampshire, Texas, Florida, Delaware, there's a bunch of others that they just don't have anything at death. Not so uncommon to have nothing. Estate and inheritance, I gave you some examples. New Jersey used to have inheritance in a state, and they got rid of both of them a couple of years ago. There are exemptions, even if there is an estate or inheritance. For instance, in Pennsylvania, I said, well, but the exception is, yes, there's an inheritance tax, but if it's going to the spouse, it's 0%, so it doesn't matter anyway. A lot of the states have that. If it's going to a spouse, that's an exempted beneficiary. Charities are exempted beneficiaries. They're not going to get taxed on that. Some of them continue on and say, okay, if you're leaving things to kids, that's an exempted beneficiary. But anyone receiving things beyond that amount, now we're going to, incur either an estate or inheritance.
One of the differences with states, right, is this issue of probate.
Yep.
So this is one of the main issues we have with Brits in America is they'll walk past an estate planning attorney's office on the high street, and the estate planning just lobs a living trust at them, which can cause some problems, right? But why? What's this whole thing with probate and living trusts here?
Yeah. Okay. So this is something too that we have to educate even fully domestic, estate clients about is. Probate has a terrible reputation, and sometimes that is absolutely warranted. But again, it is different from state to state. And so, some of these things can be looked up, and I'll direct people exactly where they should look it up. It is the county in which you reside, in the state in which you reside. And you can Google whatever that county is. If I'm sitting in Philadelphia right now, it's Philadelphia County Register of Wills Office. Sometimes it is called the Surrogates Court. Sometimes it's called Orphans Court. Sometimes it's called Probate Office. Any of those things, look that up, and they will have a page. They will tell you what the probate fees are. And some of them have some, kind of basic legal guides about like what is required when someone passes away. It's not necessarily super intuitive on their website. I will give you that, but you can at least have some idea of what probate fees may be at play at death. And you can also pick up the phone and call and ask them, and they will tell you. Okay. However, some places, I'll give you an example. Probate in the state of Delaware, my first year of practice was in Delaware, is very high. So if you have $1 million in probate property at death, you have a $17,500 probate fee. That's just the probate fee. Okay? That's a lot of money. Considering that if you moved across the border into Pennsylvania, your probate fee would be about $1,200. Okay? Pennsylvania, not a big deal with probate. Delaware, expensive. The process, however, not a big deal. In Florida, the probate fees are not necessarily large, but there is the process that is done there. You almost have to have an attorney, and so your legal fees are going to be where the probate process in Florida is going to get you.
I wasn't even coming at this from a cost perspective. I wasn't even aware of this, really. I thought the differences in probate fees were immaterial in the grand scheme of things. I was coming at it from a process perspective, that it taking months, years, and difficulties. This is just an additional wrinkle I wasn't even aware of.
Yeah, there's a couple of issues with probate. There's a couple of things that we want to look at depending on where someone is resident at the time of their death. One is, what is the actual probate fee, meaning the fee that the probate office charges in order for you to use them, and to use their services. Two is what legal fees might be incurred. Quite high in Florida, quite high in California. But then the third is, what is the actual process? What needs to be done? Do I really need an attorney to do that? Can I just file some paperwork on my own? Is it fairly straightforward? I will say New Jersey, Pennsylvania, fairly straightforward. The other issue is going to be, how backed up is the office that your probate is going to be a part of? Now, we just got through COVID, where there was incredible backups on everything all over the world, and there wasn't a whole lot we could do about it. However, if you're in a small town with not a lot of people, your probate office is probably pretty timely, and they can turn things around in a month, and you're free to go and settle the rest of the estate, and have access with the assets, etc. No problem. And I experienced that even during COVID. If you're in a small town, you're probably okay. If you're in a big city, if you're in New York City, you could be waiting a year and a half, 2 years just for them to get through the paperwork, to issue the letters, to give the personal representative the legal authority to proceed. And that's a problem. So yes, that is something we absolutely take a look at when working with someone. So you had asked about, and so what's with irrevocable living trust? In the US, in a purely domestic situation, one of the ways to avoid probate is to take assets and make sure that they are put into a revocable living trust. It takes it out of your individual name, but you still have complete control over those assets sitting in that trust. Everything is still reported under your own Social Security number. Your income tax return looks exactly the same, and you pay the exact amount of taxes. There is no avoidance of estate or inheritance tax by putting things in a revocable trust. One of the biggest misconceptions is they think, well, I put all my assets in here and I avoid all tax. You do not. You avoid a probate fee and a probate process. You do not avoid taxes.
People who think that maybe they're spending too much time on TikTok. I don't know. There's a lot of bad advice on TikTok right now.
Really
There's a
bad
lot of very confident young men. It's always young men standing in front of flip charts, writing LLC and trusts, and then black lines of arrows and making promises that are not true.
Yeah, it's so wrong. And so Susie Orman, right? This incredibly very successful, written 1 million books. She actually has a statement in one of her books. It's one of her earlier books, granted. And she says the probate fees go to the attorneys. That is incorrect. That is incorrect. Probate fees go to your local probate office, your court. Legal fees go to attorneys, and sort of never the two shall meet. So yeah, there's again, take legal advice from an attorney, not anyone else. So that probate process, very common for fully domestic people to have revocable living trust. They have a pour over will and they have a revocable living trust so that they can go ahead and fund that trust with their assets, so that if all their assets are sitting in a revocable living trust at the time of their death, they don't have to go through probate. They still have to file the taxes and, go through all that, but the legal access to the assets is immediate upon their death. Their trustee, their successor trustee of the revocable trust, has immediate legal control over the assets in there. So yes, there can be some very good benefits to that. However, when dealing with UK people, we do not use revocable trusts. Okay? There are other ways, and that is something that, Aiden, maybe on his last call, could detail, is that some years ago, there are income tax triggers that happen on the UK side when you put assets in and out of a revocable trust. So we try to avoid it. Fortunately, we can still avoid probate in other ways in the US other than a revocable living trust. You can title assets in different ways. For instance, if I have an asset with a beneficiary designation on it, that's a non-probate asset. I already have a legal document attached to that asset, like my retirement plan, my life insurance policy, annuities. Some investment accounts are offering beneficiary designation forms where you can fill that out so that upon that person's death, even if that account is in their sole name, we already have a beneficiary designated, so it automatically passes to that beneficiary and does not pass through the will of that person. Probate property means property that passes through the will. So it is entirely possible, especially if you've got a married couple and at the death of the first spouse, you may not have probate at all. If everything is in joint names, it just automatically passes to the spouse. Everything else is by beneficiary designation. It all goes to the spouse. You don't have any probate property there anyway. So every situation is different. You know, anytime any of us, whether it's the financial advisor or the attorney or the accountant, right? The client gets handed the dreaded questionnaire where they have to write out everything, all the titling, the approximate value, you know, all of those things, because it's really, really, really important. And the last part of any estate plan, you can put together the will and powers of attorney and you can sign all that. You are far from done, because the last step is, do we need to retitle things such that it is passing exactly how you want it to pass? And we make sure that all those things are updated.
Got it. Right. So, Paula, you're admitted to practice in what, New York and Pennsylvania?
And New Jersey.
And New Jersey. Right. So I'm sat in Connecticut.
Yeah.
So how would that work? Would you... How would that work? How do we get around these questions of probate and who drafts it and all that stuff?
Yeah. So here's how we work. So again, I most of what I do is federal, and so I can work with people from most states. However, it's also important that we are admitted to certain states for a certain reason, and we are committing unauthorized practice of law if we start to try to advise on state and local law in other states. Okay, so here's what we do. Like a lot of us, we represent, you know, the same people for a very long period of time. I have my clients, they started out in New York, and at some point they say, well, now we're moving to Florida. Okay, now they're resident in Florida. I'm not a Florida attorney, but my clients are like, we're not getting a new attorney. You've been with us for 20 years, you know, like this is really important. It's a very important relationship. So what we do is can get local counsel to advise on all issues of state and local law, to review everything with an eye toward that, while the relationship with the attorney is still allowed to continue. So, for instance, right now I have U.S. UK people. They happen to be in Texas. Much of what I'm doing is federal. I have a cross-border Texas attorney who is able to look at everything we're doing, sign off on it, and it usually is as quick as it is with dealing with attorneys in other countries, where you say, well, here's what we're doing from the U.S. side. Can you review this from a UK perspective and let us know what we can and can't do? Are we inadvertently bumping into something that we're unaware of? It's the same process when you're dealing with another state. Or certainly we have clients with, you know, they may be resident in one state, but they own real estate in another. And so,
of course. Yeah.
And so you reach out, you know, I have a client, they've got a nice house in Wyoming. A lot of people like to buy nice houses in Wyoming. Well, I'm not barred in Wyoming, but I know the person who is. And so I reach out, you know, Jackson, Wyoming. I'm going to reach out to you know, my firm there and say, here's what we're doing. And they're going to be brought in for, you know, a little bit of work. And it is just a little bit of work to review everything from the Wyoming perspective.
So back to me, because, you know, why not? I'm in Connecticut. I come to you. I say, Paula, help me. And if you need, I'm assuming you do, if you need a Connecticut attorney, you'll handle that part of it. If you need a UK, whether it's just asking a question or if it requires more work, maybe even a will, you can handle that aspect of it. I'm dealing with you. Yes, you might need to go out there and find it, but you have this network, you know these people, you know where to go, you can get the answers. And critically, it's not like having 3 separate independent engagements I have to manage. And
Correct. So what I describe is I am almost serving like a general contractor. Right?
Yes,
Is that if you're going to have to renovate your kitchen, you're going to need the plumber and the electrician and then the cabinet people, and someone has to coordinate all of those people. And that's where, you know, that's where the headaches are, right? Is coordinating everyone and making sure everyone shows up on time and does their job as well. So I serve for many clients as the general contractor, where I just kind of map it out and I organize it. You break it down and you go, okay, your UK person needs to do this piece. Your Wyoming council needs to do this piece, and this is the US piece. And we're going to make sure that we do this with so that the client themselves are not, again, not knowing what they don't know. They're not scrambling trying to learn this, because Lord knows they never want to do it again. When you've renovated, your fifth kitchen in your life, you can serve as your own general contractor because you know the drill. But the first time, you want to get someone else to do it.
When I have these conversations, I can't stop myself from thinking about my clients or the people I speak to. And as we're having this conversation, I'm thinking about a meeting I had this week, 2 days ago, with a couple, not atypical of people we speak to. This is a successful, came to America and have been successful. They live in California. They're worth several million. Not flirting with the current federal exemption, but several million, and they're green card holders. So domicile might still be a point of contention. So maybe there's a UK problem. I covered that in much ground with Adam. So they're in California, worth several million, green card holders, not citizens. And they have property in California. They have property in the UK, substantial property in the UK. They have a chalet in Chamonix, France. So we've got California, federal, UK, and France. Yeah. That's a lot there's a lot going on there.
But you know what? That's also the norm. Is I when I explain to people, I say I work with people with a US plus a non-US component, and it is usually not just two countries. It's usually 3 or 4. Because especially if you're dealing with a married couple, you might have a UK person who married a German, and they both moved to the United States. So now you've got 3 countries, and yes, people have a habit of buying homes in places where they don't live because that's a beautiful place to have a home. And so then they've got another country. Well, we do have the place in Italy, And so that is more the norm, is that you're looking at 3 or 4 jurisdictions with multinational clients. So yes, that sounds very overwhelming.
So they've all got the different allowances. It's all got to communicate. They've all got to be joined up. One's not got to invalidate the other. And I think people are just so overwhelmed by that. They just switch off.
Yeah, absolutely. So, and I do understand that. And so it's really important for us to explain things very clearly and kind of break things down. So what I like to do, kind of the first meeting with clients, is we kind of get on the phone, we get all that basic information, because it gives us an idea of okay, who's our team here? What do we really need to reach out about? So we can look at the home in France and say, okay, we're gonna reach out quickly to French counsel and say, what do we need to do there? Because they're probably going to need a separate French will that clearly says it is for this home only, and it recognizes that there's going to be a US will and perhaps another UK will. Let's say and your clients, sure, they've got property in all 3 jurisdictions. So they're going to have US, UK, and France. They are. And I know that sounds painful, but it really doesn't have to be. The French thing is fairly straightforward. The UK, again, because of the real estate, is fairly straightforward, and it's going to dovetail into the US, and the US will is going to say, and this will governs all of my the remainder of my worldwide property.
Paula, it's straightforward because of you.
Well,
this has been our problem for 9 years. Prior to you, it's felt like an overwhelming problem that I couldn't fix for people. It's not my job to fix it, but we're in the business of putting things that we can't handle ourselves. We're in the business of finding the right professional for that person. But this estate planning thing has been like a solution we couldn't solve for people. And because you think I've got to find someone in California who understands cross-border, and then I've got to get the UK, and then where do I even start for France?
Yeah.
But once you have the knowledge and the network which you have, you can pull it together really simply. But without that, you're the missing piece of the jigsaw for the people that we speak to.
Yeah. I wanted to touch on, if it would be helpful, to touch on residency a little bit. Because you mentioned your California people who are here on a green card. They sound similar to clients of mine who also they have a home in California. They spend some time in California. They are UK people, but they're actually domiciled in India, even though they've never lived there. So
Oh,
one might say, well, how does that happen? Like,
tell me.
and I don't really know. Like for the Indian part of it, I don't know, but they've got their advisors there, and their UK advisors agree that they're actually not domiciled in the UK. Not entirely clear to me, but so that is one of the kind of base questions: is where are you, right? Where are you resident, and therefore what does that trigger? So in the United States, for estate tax purposes, residency is not a black or white issue. Okay. And again, I'm going to stress this is for estate tax purposes, not for income tax purposes. Okay. So for federal income tax purposes, there are fairly clear tests as to whether you're resident or not. And a lot of it has to do with one, if you're a citizen, boom, you're resident. Right. Same on the estate tax. That one's easy. Doesn't matter where you physically are, doesn't matter where your income or your assets are, as long as you're a US citizen, it all gets brought in. So that's kind of an easy rule. But the second one is, am I resident? If I'm not a citizen, am I resident in the United States? So the rule for estate tax purposes is if you are considered domiciled in the US such that you have no definite present intention of leaving. All right. So the answer is not a black and white. It's not how many days have I been here or there. It is not immigration status. I have a green card. I have a visa. That's not definitive. It's a factor, but it's not definitive. So it is one of intention. So the law here takes a look at this list of factors. Where do you spend your time? Where do you own property that you live in? What is the size of that property? Is your U.S. property more like a pied-à-terre or a vacation home, or is it more like a primary residence? Depends. Where is your circle of interests? Where's your family? Again, not definitive. There are cases where you and your spouse can live in separate countries, and that's okay. It doesn't interrupt the residency issue. Where do you recite that your residence is? Do you have a driver's license? What does your estate plan say? Does your will recite that you are resident in one place or another? Where have you made burial arrangements, believe it or not? Funeral or prepaid burial arrangements. Where are you ultimately going to wind up? Because that speaks to where someone feels like this is my home. Now, so it's this list of all of these various factors that are taken into consideration. And it's a gray area. And so people can kind of lean to one way. I'm leaning more toward residency, or I'm leaning more toward not being a resident. So part of the planning that we do with people is to say, where are you? Where should you be? And do we need to take steps to really evidence that you are trying to declare that you are a resident in one place versus another? And what do we need to put in place to do that? Do we need to update your wills, your driver's license? Where do you vote? What do you recite on your tax returns? Where are your doctors and advisors and all of those people? Take a look at your list of factors, and do we need to tighten this up to really direct you to one location versus another?
Thinking about this family I just mentioned, though, the thing that came up is we just don't know. We're happy in California right now, but we've got property in the UK. Could end up there. Could end up somewhere else. As an estate planning attorney, how do you manage that? We're an expert. Could end up anywhere. Do you manage? Is it frustrating? What do you do?
No, not really. But and it is the norm. It is more the norm, and it has been sent into overdrive because of COVID, because of remote work. We truly are more digital nomads. I have clients now. There are immigration programs throughout the world that they are offering temporary visas. They're offering income tax residencies to certain people. So Malta, I have clients who do not live in Malta, but they are income tax resident in Malta because Malta has offered this program. And they are truly nomadic people. They move every 3 months. And they're just seeing the world right now because they have the money to do it. And they both work remotely. And they just change their residence every 3 months. Where are they? You know? That's a question. So there's a couple of ways to answer that question. I mean, one is that you want to declare that you are somewhere. I'm not saying it will completely avoid any fight on that because, hey, if you have enough money, certain jurisdictions want to tax you and they're going to try to make a claim on you. But we evidence as much as we can. First, we do the math on it all. We take all jurisdictions and say, where should you be? And, and we kind of map that out and say, well, it would be a lot less expensive for you to say you are Australian rather than US. People also, there is a myth out there that, oh, you never want to be US because they'll just tax you. It's always the highest tax rate. That is not true. With a 13 million estate tax exemption and an unlimited marital deduction in some cases, and the 16 estate tax treaties we have with other jurisdictions, the U.S. might just be your best bet. But you have to do the math.
He gets strategic about it. So it's like, okay, so you don't know, but what we can do though is we can paint a picture that says, for now, this is what we believe our domicile, and we'll pick, and then we'll kind of like structure things, structure our affairs, our intentions, our life around what works right now.
That's right.
I hadn't thought of that.
That's right.
Okay, cool.
Yeah.
Right, Paul, as we wrap up here, can I just address the elephant in the room? So obviously, think about this client, this couple I'm speaking to. One of the things I think that puts people off or prevents them doing anything is the overwhelming complexity. California, federal, UK, France. Where do I start? I don't know anyone. I'll deal with it later. The other one, though, is a layperson in California is thinking, oh my God, all these lawyers, this is going to be 30, 40, 50 grand. I don't know what, I'm putting numbers in their head here, but that's also terrifies people. So I'm not asking you for specific numbers, but like, how would you allay the fears of someone who's thinking, I'm in Connecticut, I've got stuff in the UK, I've got Connecticut issues. Like, how can you allay the fears of someone that's not going to bankrupt them in fees?
Yeah. Well, here's what I would suggest. Many attorneys, and I do advocate for this, is that the initial meeting with an attorney should be complimentary, where it doesn't have to be an hour. It could be 30 minutes to just get on a Zoom with an attorney and say, like, here's my situation. And I'm talking about a cross-border attorney. To get on Zoom with them, get some initial facts, and get some idea of an outline of what their estate plan is going to encompass, including any other jurisdictions that may be at play, so that at least they know, okay, here's what we need to deal with. We really won't need a separate, UK will, for instance, or it's all going to be the UK and we really don't need much in the US, or whatever it is. And then, for instance, I usually can quote a flat fee on that call after that conversation. And it doesn't include any other advisors that may be used, but, we can get in touch with them and have them do the same, for that client. So it should be, readily, first of all, no one likes an open-ended attorney arrangement, myself included. That's just scary. So you get on the phone, have an initial complimentary call, sort of get the basics together. I believe that people should always interview their attorney because it isn't going to be, anything with cross-border is not going to be a one-time thing where they then walk away and forget about it for 30 years. That's just not the kind of life that cross-border folks are leading, right? Things change all the time. So they need to feel comfortable about reaching out again, and sort of maintaining that relationship with their advisor. Certainly with the financial advisor and the accountant as well. So they need to be comfortable. So get that interview. The client needs to interview the attorney as well and say, does this feel right to me? And then, the attorney needs to sort of do an outline, quote the flat fee so that they have a good understanding. That's, works for everyone.
So just so I'm clear on that, let's say I said, you and I have an initial conversation. You come back to me and you say, right, I expect my fees for this engagement is going to be X. I do think you need a UK will, and I'd recommend this person, and I expect, or they've even quoted, it's going to be X pounds.
Yep.
And I will need to engage a Connecticut local attorney for you, and I expect 2 hours of their time, and I think that will come to X. So I'll have your fee plus either you'll tell me I do think we need to engage it, and maybe we'll even have a rough fee. So I can get, from that I can know straight away, okay, these three parties are going to come to bear, and it's going to be ballpark this amount of money, and then I can.
Yeah.
Great.
Yep.
Wonderful.
A lot of people, like, if they have that information, they go, oh, I'm so relieved. It just takes away the overwhelm.
It's the fear. It's the fear of it's half. It truly is half. It's so overwhelming, not having this network, not knowing where to go, and just putting it off. And then the other half is fees. The fear of fees, particularly in America. And I do get it. People hear attorneys and get terrified.
Yeah, sure.
They see that clock ticking and that fee rate. It's because we're all, every week there's like a massive court case and it quotes the amount of fees that so and so's, and everyone thinks, right, anytime I engage a lawyer, I'm hundreds of thousands down. And there are people for whom estate plans do cost that. They've got very, very wealthy people with very, very complex affairs.
Sure.
And it's money well spent. But for the people we speak to are successful expats. They are worth several million, maybe not in the realms of the federal estate tax, but successful, several million. They have these issues. They have affairs and assets in multiple countries. They have state issues, and it's been very hard to find a solution for them. So
yeah,
sorry. So I'm delighted that we are now in touch. I'm so grateful for you coming on and talking to us. This is critical stuff. So thank you so much.
Thank you. This was fun.
Where can people find you, Paula?
They can find me at my website is www.jonesestategroup.com. They can email me at paula@jonesestategroup.com. That's probably the best way to get in touch. Or you can call me, 484-680-1143.
Perfect. And of course, people reach out to us and we can pass you on as well. So
absolutely.
No excuses. No excuses. Right. Well, Paula, thank you so much for being such a great guest on We're the Brits in America.
Thank you so much.
You're very welcome. We'll see you soon.